I got one this afternoon.
I better snuggle up.
Working council. A working council. You ready, Bruce? Okay. You guys are ready? Welcome. Welcome. We're glad to see everyone here. The first thing we do is a sound check to see if the people on the far side of the wall and at the back can actually hear us. And if you can, that's a good sign. And then we'll continue. It's a warm summer evening, and I'm glad you took some time to come to council and see what's going on. I hope we don't disappoint too many of you. That's a foregone conclusion. We're going to disappoint some. First item is always a call to order, and I'd like to call the regular meeting of council for Wednesday, August 1st, 2018 to order at 7:03 p.m. We have an amended agenda that was circulated, and I just got a request, if I could, to move 10.4, the license of occupation, up to 10.1. So we do the first business item. 10.4 would become our first business item, and it'll be very quick, I think. And we have an insertion on 10.2, which is just a replacement page. Otherwise, the actual order of business is the same as was circulated. I have a motion from council to adopt the agenda as presented. Councillor Wright, Councillor Lutz, all those in favor? Any opposed? That's carried. We always begin our call to order also with a reminder to councillors that if there's any conflict of interest, perceived or otherwise, on issues that you're addressing, that you recuse yourselves as appropriate. We move then to item 3, which is item 3.1. We have an appointment from RTC Properties, and they're here in the front, and Chris looks like he's going to be the one who speaks to us, so welcome. And as soon as you're ready, push the button in the front and it'll go on, and we'll give Alice a moment to recuse herself because she is in a perceived conflict because of proximity to the project. She's just about out of the room. Thank you. Go ahead.
Thank you, Your Worship. Thank you for this opportunity. We're hoping tonight we're going to be able to give you a little bit of a history on this development permit application and basically highlight some of the events, some of the facts for your consideration. So with that, I'm just going to move forward, but I guess, is there a particular place to point to that? Oh. You're on?
Yep. There.
Thank you.
Just that goes
Awesome.
forward.
Thank you. So this was a... Yes, we missed it there. One more time. There we go. This was a project that it was an abandoned project. It was left for quite a few years. It was a neighborhood eyesore, defunct strata. Strata was not functioning when we got involved with them. Uncompleted buildings and roads. Buildings were occupied without occupancy permits. Units were in foreclosure. A lot of the units had transferred in foreclosure. There was no disclosure documents or anything like that, as far as we know, that were provided with those units. Land for future phases had transferred already to the lender, and order absolute through the Supreme Court was granted. Strata owners were desperate for solutions, the ones that were there, and the original owner actually was owner of several units at a time, and there was a conflict between the owner and the rest of the strata owners. I guess we have to press this twice. So these are some of the pictures, just as a history. I mean, roads were incomplete. They were just sitting there. Buildings were incomplete. The place was a real mess. The previous owner was just keeping it as kind of a storage area. Broken boats and things were left all over the place, garbage all over the place, and it was quite an eyesore. So when we came to the table to actually take over these developments, the owners of the strata, the neighborhood, and the District of Seychelles as a whole, they were all interested to see this project moving forward. Property zoning, historically the property has been zoned R4 and high density for over 37 years, since at the very least for the past 30 years, and it's been in the official community plan for high density. Allowable density for the remainder of the property that we are dealing with is 98 apartments, and allowable site coverage is 75%. So the original Form P, Blue Northern, it was for 69 units in 16 phases. 3 phases were approved as 2-story slab on grade, and 13 phases were approved as 3-story slab on grade. And this would have required a significant cut and fill and creation of a whole bunch of stack rock walls or concrete walls in order to create that slab on grade. That's the description that was in the original Form P. This original Form P was actually approved by the approving officer back in 2008. Interestingly enough, there were actually 2 Form Ps. There was an original one was signed in 2006 by the approving officer, and it was different than the Form P that was signed again in 2008. I really don't know what the history was and how the Form P was changed, but the Form P in 2006 to 2008 was significantly changed. In the original Form P in 2006, the buildings were described as 2 stories, okay? But most of them were described as 2 stories, save and except 2 buildings. In 2008, all of them were changed to 3 stories, save and except 3 of them. So it was a significant change, and I really don't know how it went about that change. So every owner in phases 1 through 3 would have been aware of the 2 or 3-story buildings regardless, because it was registered on title and it runs with the land. The building heights of the new proposed development under the new approved Form P, they're generally in keeping with the building heights and form of the previous 2 Form Ps. And the building massing along Road B, which has been the critical one that has been the subject of some controversy here, they're all pretty much the same as the building massings that are being proposed currently. There were 4. We are proposing 4 buildings versus 6 buildings that were previously approved. This is how they look. As you can see, building number 2, which was in the original phase, and building number 1 and building number 11, they were all designed to be 2-story buildings. Everything else that you see there, it was designed to be 3-story buildings, okay, under the original Form P. This is the previous development shows the comparison between the previous approved on the right-hand side and what we are proposing under the new approved Form P. Although these are 3-story buildings on the left-hand side, but as you can see, the road profile is actually the same or even lower than the ones on the right-hand side. So the profile on the left is basically a representation of a 3-story building. How it looks on the road is actually about 2 stories high. This is a representation of what the originally approved Form P looked like. That's the 16 phases that was proposed by Blue Northern. This is an artist's rendition, but it's pretty close as what it would have looked like. You know, we just tried to create it, kind of the blockings as the building envelopes were indicated on the previous plans. So the original Form P had expired. During foreclosure proceedings, the Supreme Court severed the existing phases 1 through 3 from the remainder of the property. For the development to continue, the original Form P had to be removed from the title and replaced with a new Form P that was approved by the District of Seychelles. All property owners in the original strata, Blue Northern, had to agree to the disposition of the original Form P in order for the development to move forward and to be removed off the title. In order to do that, all property owners, they had to sign an agreement, individually and collectively as the strata, which they were done. The District of Seychelles also had to agree to the disposition, or alternatively not to oppose an application by RTC to the Supreme Court, and the district chose not to oppose the application. Application was made to the Supreme Court with the full consent of all of the owners in Blue Northern and the strata as a whole, documents signed by the president of the strata, where the BC Supreme Court ordered the removal of the original Form P from title, which was then filed with the BC Land Titles Office. This only affects the property, the remainder of the property, and allows for the remainder of the property to continue. The new Form P required approval of District of Sechelt. The Form P describes just what the Form P really is. It's been subject of some controversy, and some people think that they should have been informed or notified and had the ability to engage in discussions with regards to the Form P and the decisions that were made by the District of Sechelt. That is not the case. The Form P describes in general terms the details of a subdivision as it relates to amenities, building forms, building footprints, start and completion dates of each phase, and most importantly, the unit entitlement in a phase strata. Because that is something that people, third parties, come to rely on once the development moves forward. The Form P is a form of agreement between the district and the landowner developer and shows the intent of the development as agreed between the district and the developer. And that's exactly what it is. And it was also in the disclosure document, which was provided to all of the owners in the Grandview when they purchased what we call phase 4 or phase 1 of the new development. Unit entitlements approved by the district's approving officer are binding among the parties, which is the district and the landowner, and later on those third parties affected by the subdivision, which is the new strata owners who purchased in the current phase that was transferred and the future phases. Once the Form P is signed, once the Form P is registered in the land titles, it runs with the land. And the District of Sechelt is only able to amend it once and only with respect to the timing of the phases. After that, it goes to the Supreme Court. It has to be through an application, it has to go through the Supreme Court. Since the Form P was approved, it was filed with the land titles, and other third parties have come to rely on that, okay? And all the people who have been provided a disclosure document and who have purchased in that strata. In a typical land subdivision, every parcel is assigned one unit entitlement. And, but in a case of a condominium project that is phased, you can't assign just one unit entitlement because the unit sizes vary in size. And that was actually one of the problems that the people in Blue Northern had when we got there, because there were units in there that were 2,200 square feet, and there were people who owned units in there that were 1,400 square feet, and every single one of them had unit entitlement the same. They were paying the same strata fees, which was not correct. And it also affects their ownership in the balance of the assets of the strata. So to the contrary, the people who have got less own exactly the same as the people who have got larger units, which is not correct. So in order to establish the unit entitlements, we had to develop very detailed plans to ensure that the information that is going to be provided in the Form P that people are going to come to rely on, it's going to be something that is correct and accurate. So we developed very, very detailed plans as how it's going to be, and it involved the District of Sechelt Planning Department, numerous staff members at the time, and there was a lot of people who were there and left, and then other people came in and took over their positions. But it was through quite a few meetings and over several months and phone calls and back and forth and creating those plans that these plans were developed that eventually became part of the Form P and the basis for the unit entitlements that were calculated. So the way it's done is the common practice that is done by all of the land surveyors in determining unit entitlements for condominium projects, and in this case, for proposed condominium projects. To arrive at these unit entitlements that are currently approved, these documents were required to ensure accuracy. Detailed plans and elevations were drawn up with input and direction from the district staff over several months to ensure that RTC met the DPA requirements and R4 zoning. We produce the plans, we negotiate, we discuss them with the district, and the district staff will come back because they're the gatekeepers of the zoning and everything else, and they tell us if those plans meet their requirements or they don't, or if they meet the bylaws or they don't. And we can only go by what they provide, what the information they provide us, and that's what we did. So the process involved multiple meetings, emails, and phone conversations, and numerous DOS staff members at the planning and engineering departments. All instructions from the districts were incorporated into the final plans, which became the basis to calculate the unit entitlements and the approved Form P. Now, in the Form P that we had provided to the district, it had more than just a calculation. It had the site plan, and it also described every single building that was going to be built on it, okay, verbally, as going to be a 4-story, 3-story, and the kind of construction that is going to be concrete foundations and those type of things, and basically specified what the heights of those buildings are going to be, because we had to do that, because people who were coming to purchase the future phases, they needed to know as what was going to take place. So in approving officers' role and duties, from what we understand and what we have been told, and as per the Land Titles Act, is approving officer is appointed by the council under the Land Titles Act and is employed by the district to rule on land subdivision. That's actually what they do. The approving officers are agents for the Land Titles Office on behalf of the Land Titles Office at the district. It is the duty of the approving officer to ensure that all approved subdivision can legally take effect and proceed. Okay, that's an obligation that they have. They can't approve a subdivision that cannot proceed. And in doing that, there's a lot of different due diligence that they need to do in order to make sure that it can be serviced by municipal services, et cetera, it can be subdivided, and all those things. Inherent in that is the duty to ensure that such approved subdivision conform with all municipal zoning bylaws and servicing agreements. By the same power vested in the approving officer to approve a subdivision, the approving officer has the power to refuse approval of a subdivision if, and this is straight from the Land Titles Act, okay? The approving officer considers that the deposit of the plan is against the public interest. That means if they feel that they need to involve the public, they should involve the public. That's up to them. The anticipated development of the subdivision would injuriously affect the established amenities of adjoining or reasonably adjacent properties. The land is subject or could reasonably be expected to be subject to flooding, erosion, landslip, or avalanche. I mean, we're talking about the slopes and all that stuff. This is their requirement to figure out if that's the case. And if it is the case, then they should have put in their requirement for Section 219 covenants or other form of whatever they see suitable. But the most important one, I guess, is this, that the subdivision is unsuited to configuration of the land being subdivided or to the use intended, or makes impracticable future subdivision of the land within the proposed subdivision of the land adjacent to it. And that's exactly what it is, because if the project if it's not able to move forward because the proposed buildings in the Form P do not fit the zoning or whatever may be the case, or require a height variance, whatever may be the case, then the district approving officer should not have approved it. Those things should have been checked before it was approved. The approving officer has the duty to ensure that the unit entitlements as stated in the Form P can be sustained. I mean, this is one of the most important things. Whatever development is going to be approved, it has to maintain the unit entitlements. Unit entitlements cannot change. To consult with district planning staff, engineering staff, or others as the approving officers deem necessary, including hearing from all persons who, in the approving officer's opinion, would be affected by the subdivision. Those are all the responsibility of that person. To ensure that the proposed buildings, building footprints, setbacks, and building heights conform with the R4 zoning, knowing that once the Form P was approved, the unit entitlement would be binding upon the district. Ensure that the subdivision could legally take effect. The approving officer's consideration for approval of Form P include signed consent form, and that's what we believe the approving officer did. They actually went through that. There was quite a long process of consultation and going back and forth and information exchange that took place that even included the lawyers at the time. So they received the signed consent form from all neighboring properties who would be affected by proposed subdivision, which is basically the 9 people who were part of that subdivision right at that location. Confirmation of BC Supreme Court order, which removed the expired Form P from title, allowing the approving officer to receive a new subdivision plan for examination, which is what happened. Consultation with the developer, senior planning and engineering staff. We were involved in most of those consultations and the process that took place regarding the proposed subdivision plan. A Form P with accompanying schedules, detailed description of the development, building height, setbacks, site coverage, drawings. All the details were provided to the district and to the approving officer. And comprehensive unit entitlement calculation for each phase and timeline for a start and completion of each phase were included in that Form P. It was quite a comprehensive Form P, and it had to be, because of the nature of the development that was being proposed. West Porpoise Bay Estate, what we are proposing is actually, it follows the official community plan. It is a high density development. It's smaller accessible units which are more affordable. All buildings have elevators and ground level access, covered and secured underground parking, unlike the first 3 phases that were done. Minimize cut and fill to the slopes. Minimizes the number of roads. We have reduced the number of roads that are going in there. Maintains 2-story building heights near the roads. Preserve the natural slope watershed, and proposal to expand the current waterfront park dedication. As a matter of fact, some of the buildings that were being proposed originally in the original Form P that was approved, right next to the park, in that area over there, it's one of the high, basically the parks that is there is just near the water. It's just better to expand the park over there rather than build any buildings on it, because the building would be quite difficult and it would be very, very close to, and perhaps even interfering with the 15-meter setback from the water line. So this is how the development was supposed to be, and these are the pictures of the development that is being proposed. As you can see along Road B, it doesn't change much. It's just different types of buildings. There's 4 buildings versus 6 buildings, but they're pretty much the same. Along the water on the front, 2 of those buildings have been eliminated, and we're expanding the park, as you can see, and the buildings have been pushed back. So the 4th building from the right-hand side, if you go there, that area is being expanded and added onto the park that already exists. This is how it looks. As you can see, the 4th phase that was done, which is the Grandview, on the left, on the corner over there, if I can just point to it, right there. You can see all of those things, all of those buildings over there. These buildings are much lower, despite of what people have been coming to the council and showing elevations. And this is a rendition of it. You can see the bottom floor over here is actually the storage areas, and where the units start, which is right here, 7 except 1 unit on the bottom. On this side over here, they're all overlooking these buildings over here and through this opening right here. So you can see it over here again. It's the same kind of a thing. You can see that very clearly. There is the first unit right there, the second unit right there, and the top, which is part of the second floor, that second unit right there. You can see it here again. And this is the shot from the road there. So that's about it. We just wanted to give you the facts, and thank you very much for the opportunity. Much appreciated. Thank you.
Thank you. Just before you leave, I'll just see if councillors have any clarifications. We spent a long time with our own legal counsel this afternoon, so I suspect there isn't, but there might be. Anything that councillors want to ask Mr. Meridian before he leaves? Seeing none, thank you very much.
Thank you.
Appreciate it. We'll get to it probably in about an hour, and we'll get to it then. There are no proclamations this evening, so I moved item 5, adoption of the minutes from the previous council meeting, and that's item 5.1, minutes. And we could ask Alice to come back, actually. We should wait for a moment so she can already have a reduced council this evening. Regrets from Councillor Seegers, who's in Alberta, and regrets from Councillor Shanks, who's unable to attend this evening. So a motion to receive and adopt the minutes of July 18th, 2018. Councillor Lutz, Councillor Mueller. Any errors or omissions that people noted? There's a couple of small typos if you read it as carefully as we do, but I'll ask you to read it as carefully as we do to find them. No, I'll tell you later. No errors or omissions. All those in favor of adoption? That's carried. No objections. And is there any business arising from those minutes? Moving then to, if there's no business arising, to committee minutes and reports. Item 7.1 are the minutes of the Public Works, Parks and Environment Committee. Motion to receive. Thank you, Councillor Lutz. Councillor Mueller, all those in favor. Are there any of those recommendations, 1 through to 6, that people would like to see pulled out? We'll speak to it afterwards, or do you want to? Okay. Councillor Inkster would like to introduce recommendation number 6.
No, all of them. Just
All
this
of them?
one.
Okay, thanks.
Just wanted to mention, Mr. Chair, that there was a fairly extensive discussion within that grouping of the Water Resource Center and the budgets connected to that. And after saying that, I just wanted to introduce 1 to 6.
Okay, thank you very much. And seconded. Thank you, Councillor. Right, and all those in favor? That's carried. And with that quick recommendation or adoption of all the recommendations from the Public Works, Parks and Environment Committee, that includes the recommendation to finally in 2018 install a rainbow crosswalk in Cowrie. And I know a couple of you came to hear that. So no fanfare, but it's done, or will be done. Wednesday, July 25th, the minutes of the Planning Community Development Committee meeting. Motion to receive. Councillor Mueller, thank you. Seconded by Councillor Lutz. And all those in favor? Any of those that people would like to see pulled? And there's one I would like to pull. Councillor Mueller first.
I guess we passed the amendment point
For planning?
for planning, yeah.
Not necessarily, but you'd want to pull any of the recommendations so we could.
No,
amend
it
it
wasn't a
at that
poll,
point.
but I believe I was just
Sorry.
raised an error by our director. I wasn't at the meeting, so I'll allow her to speak to it.
Okay.
Sorry, there's
Director
just
Corbett?
thank you. There's just a quick correction under recommendation number 12. It has the incorrect address there. Instead of 4461 Whitaker, it should be 4648 Whitaker Road.
Yep. Well, that's actually the one I wanted to pull for further discussion. So with pulling number 12 for further discussion, and I'll explain why in a minute, I'll look for somebody to move recommendations 1 through 11 and 13, 14, and 15. Councillor Mueller, Councillor Lutz, thank you. All those in favor? Any opposed? That's carried. And recommendation 12, which was the accessory building on Whitaker Road, I asked to be pulled because I watched the planning meeting as it was happening, and there was 2 issues that I thought needed to be addressed. One of them was that this was in front of the committee so that they could hear, so the staff could have guidance on how to deal with development permits as it went forward. And secondly, I thought that there was only 3 members of the committee there, and usually we look for a majority to bring things forward. And in this particular case, I heard nothing in the committee discussion in the approval that made me think that it was in fact the council's decision. And the issue here is whether or not, what's the meaning of a ancillary cottage? What's an ancillary building? What's an ancillary dwelling unit? And the combination thereof, and how that fits into the planning and neighborhood plan issues in terms of streetscape, etc. I was wondering if the director would be able to give us a recap for the 3 of the council members who are here tonight. Were not at the committee meeting and may not have heard some of that discussion, but I'd like it to go over again.
Thank you, Your Worship, members of council. I did include the PowerPoint from that presentation, and I also had possible motions on it, so I thought it might be instructive
Thank you.
to look at. Okay. It will be marked with the item. Okay. Thank you. So the discussion at the committee rested on how this was defined, what was acceptable, what kind of standards should guide it. The application itself was for 4648 Whitaker Road. A guest cottage is allowed under that zoning. It does have a maximum size on it, and then the question was, because of the way some of that is interpreted, did it actually mean that it could become a two-story with garage, which is usually classified as a coach house. This was the guest cottage proposal. It is in the front yard of the area. It's parking on the first floor, dwelling unit above. That doesn't show well, but it was in your package of where it is sitting relative to the principal dwelling, which is at the far rear of the house. It's a long lot on a sloped lot adjacent to the driveway. Access is off that driveway. So the planning concerns were around the definition of use, the definition of size, of how we interpret the floor area, the siting standards. Because in our bylaw we say an accessory building does not include a dwelling unit, what are we using to guide these kind of decisions? Should it just be in alignment with what we do for single family detached? In this particular proposal, they have met the setback requirements for a single detached unit. And then the other was, and this was more for informing us moving forward into the new zoning bylaw, should there be different standards if you're in front yard versus rear yard? In terms of definition, this is how guest cottage and granny suite is usually thought of. It's usually a 1-story or 1.5 structure, whereas a carriage or coach house is defined as one that is actually over the garage. That's kind of the conventional definitions of it. So the options were, so the discussion was, we've interpreted it over time, and there's another number of examples throughout the district of where the 2-story has been applied and been acceptable under these standards. It falls only within the R1 in terms of that lot size. The initial recommendation was that council refuse the DP application as it wasn't consistent with the provisions of the zoning bylaw or the applicable development permit area guidelines. So the discussion at committee was along, do those guidelines actually apply? And it appeared they did not. So the alternative motions that I put forward is really how it would show up in the development permit. One motion being that it allow for the 1-story guest cottage, it be subject to the setbacks that would apply for a single detached house, that the height not exceed 4.5 meters, that's a 15-foot house to peak of roof, and that it not be used for short-term rentals. That was one of the recommendations of the committee. The other alternative motion is that it allow for the 2-story, subject to the same conditions, and then the last condition that we would add is that it be developed in alignment with the geotech. That goes on all our development permits. That concludes. Thank you.
Thank you very much. And what I heard from the discussion was actually very little rationale. At one point, one person said, well, I'm okay with it. And that was the extent of the consideration of planning issues. And when the director's and staff position was actually to refuse the option, I thought that council should reconsider it and look at it more closely here. I have spoken to a number of people in the neighborhood, the immediate neighborhood, and For example, on either side of that lot, one is very much in favor of it and sees no problem whatsoever, and one on the other side thinks that 2 stories is not appropriate. Nobody is opposed to a single-story cottage, and that's what I recall the 2006 and 8 discussions being. Now, I wasn't on council at the time, but I remember them talking about the granny flats and the places on the back of the properties. This one being at the front of the property, I thought should come forward, because in my view, we do have to take into consideration what the neighborhood planning principles are, and the streetscape along there is entirely single-story, with the exception of a very large 2-story, which is above grade, further down Whitaker Road almost next to the small Lutheran church. I'm not sure when, that was done before the district of Sechelt became a district, and it's very clearly doesn't conform to anything that people would consider to be normal planning principles. In this case, I think the question for council is whether or not a guest cottage is in fact a smaller building, or whether in fact it's a full 2 stories as allowed by the residential if it was a home. And when I talked to people in the neighborhood and those who were involved in the OCP development, it was most of them thinking we should try and keep the streetscape to the 1 story. So I wanted to bring that to council so you could consider that. And consider what the staff recommendation was. Councillor Inkster?
Yeah, thank you. I thought that the final result was a single story, but you're alluding to a 2nd story.
Yeah, what was before the committee was in fact a 2-story, what we would normally call a carriage house, but it had a full story with parking, though you can't control the use once it's there. And then the guest cottage, the 55 square meter footprint, was on the 2nd story. Now the entire footprint is the same in terms of what it's on the lot, but the size and the height, and therefore the visibility, and the one neighbor who's quite in favor of it will have no visibility of it. The one neighbor who's quite concerned, it will be right in front of their deck. So that's obviously what it's about. It's about how the streetscape actually looks when you're walking along Whitaker. And if you know that street, it's all small cottages, which I think the small cottage would fit quite well. In fact, it's about a block away from the Green Cottage, for those who know the Green Cottage on Highway 101 in Wesley. And it's right one property away from what I call the Pearson Cottage, which is a small yellow cottage right at the bottom of Wesley Road. So the streetscape of that neighborhood is mostly 1-story cottages.
Yeah, the further to that, there is two-story structures on Wesley. One at the highway and one back a bit from that, although it's a smaller home. So
not on Wesley. There's a 1.5 story, 1.5 story on the right or left, depending on where you're coming from.
There's a 2-story at the highway on Wesley.
It had a 2-story addition put on about 10 years. Yeah, for a B&B.
Yeah.
Councillor Mueller?
Yes, thank you. I was one of the councillors that originally voted against the motion to defer because I thought it was something that we could deal with on council the night that we first came. With this particular one, I just look at the highest overarching vision of how we're developing Sechelt, which is to entertain small increments in density and small changes to neighborhood character, and to gradually infill around areas of existing infrastructure. And seen through that lens, I can see how this particular one could be acceptable. However, issues like this, which are of a major policy type, I don't like to discuss when we have an actual example right in front of us. And that was one of the issues why at council, my questions to the director were about what was currently allowed and what changes to the building could be asked for in order to make it conform at this current stage. The policy I think we have to discuss is separate, because this has wide-reaching implications, as the mayor said, about how our neighborhoods will look. But seen from the view of how Sechelt is developing at the very highest part of our vision, it's not problematic. We just have to make sure that the rules apply to all and that they're understandable and applicable.
Just I have a further.
Councillor Inkster?
Yeah, I noticed the the piece of the recommendation that included a stipulation that it not be short-term. And my question would then be, because obviously I don't have the presentation in front of me other than the planner, and I wasn't part of the discussion, but I would then ask what was the purpose of the building then if it wasn't that particular piece? If in fact it was to be a guest cottage for friends or family, and then we would consider then that it would be an affordable housing opportunity, if in fact it's not short-term rental, I get stuck in a spot where, because we've talked about carriage housing and forms of smaller housing in the lanes of downtown Sechelt and other places that have lanes, and this is one of those opportunities where somebody may be, because I don't know why they're asking for it to be built, that there may be an opportunity to provide affordable housing. And these are, we talked a number of years ago about carriage housing and or smaller housing on lots in order to create affordable housing opportunities. There hasn't been a lot of that. I'm wondering if this is an example of that, and whether here we get stuck between what may be a small change to the neighborhood or the roof lines as we look up from Whitaker, and whether it's meeting the need for the provision of affordable housing, not knowing why it's being created.
We can't concern ourselves with why, because we can't really police that. Guest cottages, as you suggest, might be for family and friends that are guests and coming, but in fact, the reality is that they're likely going to be into a rental market of some sort. It was Councillor Lutz that suggested it be restricted to no short-term rentals, so that, given the location, I have no objections to it being short-term rental. It seems if you're a block away from Davis Bay Beach, that's probably the place you might want short-term rentals, but without too much. Again, it's a planning thing. We haven't really stopped to think about where we should encourage short-term rentals and where we should encourage long-term rentals. And the key thing, as Councillor Mueller is saying, is that we don't have a policy that's a high enough level that we can leave to staff, and yet then we come in front of council treating it as a major variance, which doesn't seem like a major variance, but that's because of the policy restrictions, and then it looks like an individualized situation. But planning often is street by street, and so that's what I'm left with. I would actually, I don't care at all about the short-term or long-term rental. I think affordability is a really key issue, and in my view, increasing the density on this particular lot, or basically on any 2,000 square meter lot in Sechelt, particularly those that are not on sewers, will make all of those lots more costly. They will not be affordable next time they hit the market. And everyone who owns a 2,000 square meter lot will realize that they in fact have a density boost coming. So there may be some short-term gain in terms of rental accommodation. Long-term costing of the lots and the value of the lots will be going in the opposite direction. So you can't win it both ways. Councillor Lutz, and then
Thank you. And my thinking around no short-term was the neighborhood as far as traffic, and we're finding that it isn't just one or two people that check into a short-term rental in a lot of instances, and I thought in this location it could cause some problems, whereas a guest cottage, it would be short-term, maybe a couple of weekends or weeks in a year, not ongoing, that short-term rental could be. I also felt that because we haven't had very descriptive pictures around what is or isn't an accessory, what's a guest, what's a lane, what's a carriage house, that this particular site as a minor development could be approved to go ahead, followed by the recommendation 13 that we do some serious rewriting of all of those kinds of descriptions. So that was my thought going through that meeting and why the motion came out the way it did.
And thanks, that reminded me, if I can go to the corporate officer, I think there would be no restrictions on who may or may not be living in dwelling units. I think the only restriction is no more than 5 unrelated people in a household. Is that still on our books, or is that something that's not in our books? Just as accommodation on the site.
It's under, that passage is under the definition of family.
Definition of family.
It's still in the zoning
It's
bylaw.
still in the zoning bylaw, because I've heard a couple of councillors suggest that this was actually intended to be a cottage for guests of the family, as opposed to a 12-month rental for somebody, and I don't think we can make that distinction. I think once it's there, it will be rented out in one form or another, and unfortunately, we can't police that. I know there's 2 properties away from this, which has 3 distinct units of dwelling on it. Garage has been converted, secondary suite, and the main house. But I don't talk to bylaw officers. Well, you can't. I mean, you live in the neighborhood, you just can't. So we're a bit of a dilemma. Could you put the recommendations up again that staff had come back to? And I'm thinking actually that it's the third one with a slight restriction in height that might make it fit into the streetscape and still allow the guest cottage to go forward, still allow it to be a rental of some form, whatever it is. But it's the fact that it would actually be looking like a cottage when it was finished and not like a 2-story structure. Councillor Mueller, and then...
Yeah, I just wanted to reiterate my question that I asked last time, but I think it got kind of lost in the complexity of the discussion, which is I don't want to get into policy changes that might happen. As it currently stands, what aspects of this building design make it non-conform? Because I think some of this discussion has been lost in nuances of guest cottage, granny suite, and these other types of things that are not, we know they're currently not as well defined in our policy as we'd like, but from a building standpoint, what parts of it are non-conforming? And I remember height was raised as an issue, as well as use as a carport. So perhaps our director can provide some insight on those issues.
The issue was under the zoning bylaw for guest cottage, the only thing it prescribes is a maximum size of 55 square meters. So that's what the top of that dwelling is around there. How it has been interpreted is that under the definition of floor area, it excludes ancillary parking from floor area, and that has been used to justify why it doesn't count. And so you can have a 2-story parking underneath it and it not count toward the maximum floor area. So by doing that, in my mind, it made it into something different. And so why I brought it to council was to get some direction, because there wasn't a lot in the zoning bylaw to in terms of regulations or definition. When it came forward initially, was that the intent? So it's just seeking some direction on that. We can move it forward. It has gone. There have been a few examples throughout the district where that has, in fact, been the case, and it's gone forward, and they're in front yards. I was just seeking some direction on that's a little bit of an unusual crafting. Was that the intent?
Did you follow that? The 55 meters was intended as the guest cottage, and that was clear. What wasn't clear was, could that be put on top of a 1-story building? So that's actually 110 square usable meters. So it might seem black and white, but it didn't seem black and white to the proponent, and it didn't to the director, because the director and planning staff were caught with no clear guidelines whatsoever. Because if the same thing was at the back of the lot, it would be acceptable. So it is about planning, design, and streetscape. And we don't have regulations yet, which we do need on how being on sewer makes a difference for these lots as well. This one will have a new septic system in place at some point, but not on our sewer plan for another couple of years or more. And Councillor Wright, were you? Councillor Wright and Councillor Mueller still thinking, pondering that.
Oh, thank you, Your Worship. Through you to the Director of Planning. If the proponent had called this a carriage house or a coach house instead of a guest cottage, would we be having this discussion?
Through the chair, the applicant did call it that. That's what is on the application, and that's what's in the geotech report. Where it gets confusing is that that's not a use that we actually define. So we don't have provision in our zoning bylaw for coach house. Right. Instead, the convention, and I'll clarify, it was not the applicant who made up that definition. That was coming from the district. The applicant was following what he was told was acceptable. It was the director who questioned how we do that because it seemed an unusual interpretation. So this is not on the applicant, it's me. And so what I was seeking is that the intention? Otherwise, we should be clear on that is allowed because there is certainly a demand for it.
Thank you.
Councillor Inkster, and then I'll see if anyone on council wants to replace recommendation 12 as before us with the recommendation that's on the screen, and if not, we'll go back to recommendation 12 and see if it has the support of council. Councillor Inkster.
So obviously with the technology available to us, I have an aerial view of the property.
Yep.
And I'm just wondering if in fact the location of the building is on the grassed area just in front of the house, or will it take out the trees just below that? Because I know the area and I know it's up above the road. So there it is right there. Thank you. So that's it right. Oh no, that's this.
No trees whatsoever. It's on the lower left corner.
Oh, it's right at Whitaker.
Yes, it's on the streetscape. That's the whole point.
Well, these are things I don't.
Yeah.
I wasn't at the presentation.
Yeah. So
Okay.
the driveway curves around behind it, and the neighbor's driveway starts basically where the DL is in the next lot. It goes that direction, and the other neighbor, as you can see, crosses off at the bottom on the right.
Okay, and obviously it's set back.
It'll have
Property?
normal setbacks. Yeah, 5 meters.
It does? Okay. And it's, okay, we're looking at the one-story
And
motion.
it'll impact residents on number 5, have no impact on residents in lot 7.
Will the single story have an effect on the deck that you referred to?
I don't know. I don't think so, but single story is well within the limits, and it's what is normally envisioned. So I would support the single story just because that's what I think was intended when we put that zoning in place.
It may limit the use as well.
It will.
Yeah, which is still affordable housing.
Yeah.
Okay.
It won't limit the dwelling portion at all. It won't limit the affordable housing aspect of that's what it is.
But it might limit the other pieces.
Might limit the parking.
Yeah, that we're concerned about.
And it is, I never knew what the definition of auxiliary parking was. What's primary parking? They had auxiliary parking, kept talking about this, and I know that this is the prime house and the parking will be up at the top of the hill. Nobody's going to park their car at the bottom and then walk up. And yet they had continual references to auxiliary parking. I don't quite know what that means. Director can't help me on that either. There's a lot of cleanup needs to be done. So the question before council is either support for recommendation number 12, which is that it be approved as a minor development permit. That is 2 stories, 55 square meters and 55 square meters over 2 stories with a height of whatever it would be, or the alternative motion here, which restricts it to a height of 4.5 meters at a peak, if it's done as a peak roof, which, back one? Which is, as the committee? Oh, that's a good question for the corporate officer. I asked that this be pulled from the recommendations for consideration. Does that mean it's on the table and on the floor? Or-
Your Worship, at this point, there was no mover and seconder that would have put it on the floor. It's just been pulled from the
It's been
minutes
pulled,
of
so
the
it's
consent
there where it is. Okay, so then whatever we put on the table will be on the table.
I'll put motion number 1 as presented there on the table.
And
Can you speak into your mic, please? You can't hear you at all.
Sure, sure. You've been talking to somebody behind you. I'll propose alternative motion number 1.
do we have a seconder? No? Okay. That's a clearer sense of what number 12 would have been. Anyone to move motion number 2? Councillor Roots does.
I'll move
And
alternative motion number 2.
And seconded. Okay, that's seconded. Any further discussion? Councillor Mueller? Councillor Wright, actually. Councillor Mueller first.
Yes, thank you. This one, it's unfortunate that we're dealing with it in this way. I think that we really need to have, the onus is on us to make sure our policies are really clear and understandable to any applicant. And in this one, there is some gray area. And for that reason, given that it fits within the wider vision of what I see Seashelt's wider vision to be, I would be prepared to vote for the recommendations as they are, and for us to come back and deal with our policy so that it's clear for all future properties.
Councillor Wright is second, and then Councillor Inkster.
Well, thank you, Your Worship. I understand the concern about the streetscape that you spoke about, but like Councillor Mueller, when you don't have a policy that's guiding you, I find it very, very difficult to turn around and tell a proponent, no, you can't do that. And I think that at this particular point in time, we need to move this particular development forward and then look after our policy so that we have that covered in the future. Thank you.
And Councillor Inkster?
Yeah, I put the other one forward. I thought it was a good compromise position to have a shorter building in an area with that would more predetermine the uses than this particular one. We can say that it not be used for short-term rentals, but based on the size of it and the fact that it's proximate to the beach, that it could be used for a wide variety of things that may include that without necessarily our knowledge or control. I don't think it necessarily fits. I would have preferred a one-story building. I think we should have been more, and in this particular case of a neighborhood that will have some change by this, been a little more prescriptive. So I can't support this.
Yeah. And I'll say that I won't support it either. I think it's totally unfair to single out one single-family residential lot in the entire district of Seashelt and say no short-term rentals. There are some strata title and councils that say that, but to actually put that restriction on the only single-family residential lot in Seashelt is bizarre. That's one reason. And to Councillor Wright, and Councillor Mueller, when our policy is vague and blank, it comes to council to make value judgments. That's why it's in front of us, precisely because there is no policy, and we want council to make real-time decisions about what they care about. So we've had discussion. We have a motion on the floor. It's written there for people to see. All those in favor? And those opposed? It's 2 opposed, but it carries 3-2. Thank you for the time. I think that was actually an important discussion and important direction probably for the Director of Planning. Decisions, there was also a motion to bring policy back for further discussion. I think that was 13. I hope you have enough. They're actually, again, we're asking staff to come up with the options and definitions and standards, but
I just ask a quick question on the amendment, or on the recommendation. It did have in the last part about short-term
Yes.
rental. Do you want that taken off?
no, that was passed. That was
Okay,
passed.
all right.
They wanted it there. I spoke what I can't influence council. We move then from committee meeting minutes and reports to bylaws. We have for 3 readings tonight, item 8.1, District of Sechelt Council Procedures Bylaw. And we'll start with a motion to receive a report from the corporate office.
Earlier, the council adopted the agenda amended with 10.4 coming forward as the first item of business.
That's on 10, and I moved that forward to the first item of business items. I hadn't thought of it as bylaws.
All right, so sorry.
We're not at business yet. Bylaws, sorry, Sanath, you'll have to stay a little bit longer. District of Sechelt, first a motion to receive the report from the corporate officer. Councillor Mueller, Councillor Lutz, all those in favor. And briefly, if you'd like to speak to this, and then we'll look at it.
Thank you, Your Worship. This, as noted in the report, this item is coming forward further to Council's consideration of its current procedure bylaw, which it did at a committee of the whole meeting earlier this year. The report's before you. It itemizes the various suggested changes, and so a new draft bylaw has been presented with those changes.
Okay. And the bylaw itself starts on page 27, District of Sechelt Council Procedure Bylaw number 568, 2018, a bylaw to provide for the procedures of council and committee meetings. Could I have first reading moved today by Councillor Lutz and Councillor Mueller second? All those in favor of first reading? Any opposed? That's carried. And second reading, and this is on page 44, is moved by Councillor Wright and seconded by Councillor Inkster. Is there any discussion at second reading? Anything that people would like to point out and see or amend? Councillor Mueller.
So thank you. Yes, I recall back to when we discussed this, and I recall my my only real issue was around section 9 and the meeting etiquette. And what I see written here is not fully what I recall from the discussion. I think that it needs to be strengthened. For item 2, to refer to attendees in the public gallery, as well as council members, delegations, and include all manner of participants at council meetings to discuss in a respectful way and refrain from action that may interrupt or disturb the council meeting. I feel it needs to be strengthened overall.
So it would be amended to include attendees in the public gallery, delegations, and others at the meeting shall be respectful of others speaking and refrain from any action that may interrupt or disturb the council meeting. Would that be?
Yes.
So I'll take that as a motion to amend 9.2. So after it says attendees in the public gallery, comma, delegates, and others in attendance shall be respectful. All others in attendance. Seconded? That amendment, Councillor Lutz. Any discussion of that?
So,
Councillor
sorry,
Mueller?
if I may, Mr. Chair, the reason why I felt this really needed to be strengthened is just more to put it in a kind of foundational perspective of what we're trying to achieve here. Very often we're dealing with contentious community issues, and people feel it's free amongst them to show disrespect to others, both in the gallery or to council or to delegations or presenters. And I think that that's fundamentally against what we're doing here. And I feel like that is the key thing in this procedure bylaw that needs to be strengthened on behalf of our community.
Okay. So we've made it much more inclusive to basically all those others attending. And we do sometimes have people who are not in the public gallery but come into the door, stand there, and I can remember calling the RCMP on one occasion. Any further discussion of the amendment? which is an amendment to 9.2, which is on page 31 of the agenda package. If there's Do you want it read back? Councilor, Corporate Officer Ken, I think, just because I read it twice, but I'm not sure what was written down. Attendees in the public gallery, comma.
So section 9.2, meeting etiquette, will read in full with the amendment. Attendees in the public gallery, delegations, and all others in attendance at the meeting shall be respectful of others speaking and refrain from any action that may interrupt or disturb the council meeting.
So, I mean, I'm not sure exactly what that means. So somebody that's talking in the audience, or, I mean,
That'll always be the call of the chair
yeah,
in terms of what's respectful and not respectful. Committee chairs will have to make that judgment call, and the mayor, if the mayor's here, will make that judgment call.
okay. I mean, I know that obviously you do, and chairs have over time make that call, and I know what Councilor Mueller's trying to do is make it, you know, limit that kind of those kinds of actions and discussions, but this is, I mean, I have to think about it because I didn't know this was necessarily coming forward, is that this is a public building for public discourse and public discussion. How much do we want to control what is discussed amongst the audience members? And how will that be interpreted?
I think the amendment on the floor
Yeah.
is that people in this room, when we're having a meeting, will be respectful. Shouldn't be too hard demanding. Yes, and I'll call Pam out in a moment if she speaks even above a whisper. That's the intent. And it's actually not for the attendees, it's to give authority to the chair of the meeting. This is our procedure bylaw, which we're bound to, so it'll give the chair, whoever, committee chair or council
So
chair.
it gives, it in a sense, gives the chair more, under the chair's discretion to make more clear decisions regarding that particular aspect.
Yeah. I don't think we'll be spelling out.
Okay. Yeah, I just get concerned as to how we restrict and or discourage public discourse in a place of discourse, so.
Okay.
Yeah.
Any other discussion? It's going to include councillors muttering under their breath, too. Any further discussion of the amendment before us? Councillor Wright. In support of or not?
Thank you, Your Worship. The intent is that we do it respectfully, and that's it. And, I mean, it's pretty clear, I think, at least to me. Thank you.
Okay, any further discussion? And if not, I'll look to call this motion for the amendment to 9.2 on our council procedure bylaw. All those in favor of the amendment? Any opposed to the amendment? That's carried with one in opposition. Any other discussion on second reading of the council procedure bylaw number 568, 2018? It is an important document, and it's something we started looking at in 2015, and it's taken us 3.5 years to get it back in front of us. If there's no other discussion at second reading, I'll ask for all those in favor of second reading of council procedure bylaw number 568 as amended. All those in favor? That's carried. And third reading is moved by Councillor Lutz and Councillor Mueller. And all those in favor of third reading? Any opposed? That's carried, and that'll come back for adoption in a couple of weeks. Item 8.2, we have a zoning amendment bylaw number 25288 in front of us for adoption. And first, a motion to receive the report from the municipal planner. Councillor Lutz moved and seconded by Councillor Mueller. Thank you. All those in favor? It's carried, and it is for adoption. Was there anyone to speak to it tonight, or? Let's just move straight to the bylaw, which is number 25288, and it's had 3 readings, and moved for adoption tonight by Councillor Wright, Councillor Lutz. All those in favor? That's carried. Now, we would move to business items, and we wanted to rearrange those so that the first one was item 10.4, which is a license of occupation for Trail Bay Coastal Flood Mitigation Signing Authority. And first, a motion to receive the report from the Manager of Engineering Services. Councillor Lutz, Councillor Mueller, all those in favor? That's carried. Staff going to speak to this report, or corporate officer, or Snath, or just look for questions, or maybe just explain what the situation is?
Thank you, Your Worship. As set out, this relates to the Trail Bay Coastal Flood Mitigation Capital Project that was, or Storm Sewer Pipe and Outfall Capital Project that was approved earlier this year. As part of the project, in order to move forward with Ministry of Forest Lands Natural Resources, it is necessary for us to enter into a license of occupation with the ministry to give them the authority for the two of us to work together on the land. That's the basic administrative reason for it. If council has any questions regarding the actual project, our manager of engineering services is here to answer any questions.
Thank you very much for that. Any questions from councillors, either of the project or of the process? Councillor Mueller?
So I was just, maybe it was mentioned somewhere, but I missed it. So the firm that we originally assigned this to no longer able to do the work. Is that correct?
Mr. Bandera.
Thank you, Your Worship. There's no license of occupation for this particular outfall. We have two outfall. One is at Ocean Avenue. Other one is in Inlet Avenue. Inlet Avenue, we have that license of occupation, but this one is not.
So it's the same firm.
This is the first time we are applying for that.
Yes, but who's doing the work? Is the contractors changed or not?
There's no contract, there's no agreement.
It hasn't been done yet because we don't have the license of occupation. Yes. Okay. So it's in an early stage. So the motion on page 239, item 10.4, that the mayor and corporate officer be authorized by council to sign an interim license agreement leading to a statutory right-of-way agreement for the storm sewer pipe and outfall on behalf of the District of Sechelt for a period of 25 years for a rectangular portion of land on the Trail Bay foreshore around an existing storm sewer outfall, which is obviously existing without a license of occupation. Moved by Councillor Inkster, seconded by Councillor Mueller. All those in favor? That's carried, and we will try and get into compliance and do what's appropriate there. That was carried. Thank you for attending. Glad you could answer one question. Moving on to item 10.1, which is the Wade OCP rezoning, pages 79 to 100. First, a motion to receive the report. Thank you, Councillor Lutz and Mueller. All those in favor? That's carried. And we'll look to the Director of Planning, and I'll just say in passing, it's always easier if every department uses the same formatting, or even those within the same department use the same formatting as I look at the next report. Just makes it easier to follow. Ms. Corbett.
Thank you, Your Worship, members of council. The item in front of you is for consideration of the applicant's revised proposal and seeking direction on a second reading related to this. So this is a development that covers 3 lots at the corner of Wharf Street and East Porpoise Bay. Current site is an R2 residential zoning, and the applicant is seeking to rezone this to a special comprehensive development zone. It's located within the downtown Sechelt area within the OCP, and one of the lots is within the multifamily mixed residential OCP designation, and the area is within the urban containment boundary. So the proposal is to, in the revised one, is to go from 47 units. Under that application, it did require an OCP amendment as well as a zoning amendment because it exceeded the maximum allowed even with density bonusing. It was a 6-story at 19.62 meters. Following the public hearing, there were a lot of issues raised through that, mainly on the height, not exclusively, but mainly on the height. There were concerns around the massing, the impact on trees, the streetscape. There were issues raised around just the accessibility of that particular intersection and some traffic issues mentioned. The applicant has come back with a revised drawing. It's dropped it from 47 to 41 units, which still creates it as a high-density residential, but it reduces the need to do the OCP amendment. It's now at 4-story and 13.5 meters. I think in my report I actually had that at lower, but the revised drawing that came in after the report was completed noted that it was 13.5. This is now the new drawing that has been proposed. It's quite a different footprint from what was initially there as the 6-story. They've tried to maintain as much of the unit count as possible. In terms of zone comparison, in the CD 42, so I based the measurements on the gross area, the larger before the road dedication. The density of that is 41 units. And with that, with the rezoning, the amenities are 4 affordable units, 100% built green gold and 100% adaptable accessible units. Under a conventional R4 for equivalent to this site, the density base would be 20 units, the height would be 10.5. The parking equivalents are the same. In terms of the decision-making chronology, this was first brought to Planning Community Development Committee back in November 2017 to see if there was an appetite to do such a significant upzoning. It was supported at that time, and as a result, the applicant decided to increase it further and brought it back with an OCP amendment, hence why it went back to Planning Committee. APC recommended the proposal be denied. Their concerns were predominantly they had concerns around the height, the massing, the impact on the neighboring project at Wharf Place, and issues related to the views. Council gave first reading in April of 2018. The public hearing was held on May 23rd. And on June 20th, when it came back for second and third, Council did not give second to the bylaw. It was referred back to staff with a request to reduce the height. In terms of, just to give you some site context, because whatever kind of happens with this zoning, it will set the stage for a lot of the redevelopment in this area, and particularly on this intersection. And there isn't actually policy direction around what this particular area will look like. It's not part of the vision plan in terms of the actual node here, or if one was implied. The only policy direction is really along Wharf Street about incremental change along there. That first picture is looking kind of kitty corner from the project site. A lot of the surrounding area is single detached. Certainly redevelopment opportunities around there. It's very close to the Ebb Tide community and certainly within walking distance of the downtown, but the surrounding context is quite low. This second picture is looking into the site. I'm just standing across on Wharf Street. On the following one, in terms of the context, that blue house is actually on East Porpoise Bay. That's at the very end of their site, so this would be the end of the project site area. In the other one, I'm actually behind the Wharf Place building, standing on top of their concrete wall there, and photographing into that is the small white house that is adjacent to Wharf Street. So this was the initial proposal that went to the public hearing. It does have a commercial component in the front at 93 square meters and a 45% lot coverage. This is the revised 4-story. It's the comparison to it. This is how it would look adjacent to Wharf Place. This is looking across the street from Wharf. This is how it lays out on the ground. In terms of lot coverage, the applicants have utilized a previous gross area that was taken before the road dedication. So the actual net will be higher than the 54%. I'll go in greater detail around the right-of-way further into the discussion, because it certainly affects the site and it affects how that can actually develop. The underground parking structure is reduced somewhat. Some of the parking now as a 4-story will come onto the surface. This is the proposed landscape plan, essentially replanting along the sidewalk area. In terms of the road access, one of the challenges in terms of developing on a site like this, or just this whole area, this is a major goods movement route. In fact, it's the only one serving the Sechelt Inlet industrial area. It was certainly one of the conversations that took place internally in terms of we've got some competing objectives here of trying to do a very urban, walkable node in that area, but without the option to do a second goods movement opportunity there. They have requested that it be widened, that there be a channelized turn in there. When the other side develops, that will be a requirement to expand the left turn on that. So this particular side of the intersection is a challenging site for that reason. It's competing with a different type of traffic. As you can see, the way it comes in with the sidewalk, it does lose a little bit of that connectivity from up Wharf Street. So this is looking right at where the sidewalk will have to start angling in. There is no continuation. You can see it on the other photograph where from Wharf Place it just stops. And so that will be required to turn into the site by quite a bit. This shows the area that gets netted out for the road area. It certainly, and this is one of the things that certainly affects their lot coverage, is the developable area within the lot is altered. This is in your package. It doesn't come out particularly well on this, but it was an area where it will be challenging to respond to some of the residents' views of needing to improve access and the walkability and the crosswalks in this area. For that reason, when you channelize a turn lane, it does make it challenging from a crosswalk perspective. So in terms of the recommendation on here, it's looking at if the proposed change is acceptable, staff can work with the applicant to revise, bring in more detailed information, and we will revise the bylaw accordingly. or we would seek direction on what would be an acceptable alternative. So alternative motions would be that the council refer the application back to staff to work with the applicant to amend the proposal, however you think it should move forward, and bring it back for further consideration, or that council deny the application. That concludes my presentation.
Thank you very much. Could you keep the PowerPoint up there, actually? Could you go back to the slide that showed the comparison to the
two buildings?
No, the two, the R4 zoning and the CD zoning. It's about 5 or 6 in. That one. So existing zoning is R4?
Sorry. No, it's R2. It's a very low zoning that is on this, so it doesn't need to meet the R4 in any way. It's zoned very low, so they're asking for quite a significant increase. I just thought it would be interesting to compare across R4 as what Wharf Place is.
Mm-hmm. And at the moment, there's 3 affordable units on the property. It's basically
yes,
3 units.
correct.
And the density, we go through R4 through to 41 units and with an extra 3-meter height. And in return for that density lift, we would get 4 affordable units, and they would build to good standards.
Correct.
High standards, which are marketing. Questions of the director, and we might want to remind ourselves why this doesn't go back to a public hearing at this stage either, because there's no longer a requirement for OCP, and because of density is actually I'll let you speak to that.
Your Worship, in terms of public hearing, it can be at your call if you choose to do that. Under the legislation, which I wrote out in the report, if you're not increasing density or changing the use, you're not obligated to go back to a public hearing if you were decreasing. What you would be required to do is to notify the applicant that you are doing that, but there's no obligation to reopen the public hearing unless you felt that there was, if anything was changing so dramatically, you felt the need to put it back to a hearing.
Okay. Thank you. Councillors. Councillor Inkster, Councillor Mueller, Councillor Inkster first.
It'd be, if we could have the 2 pictures as well, the comparison of the 2 buildings go up. Thank you for that. Thanks for providing all this information to us to help us with our decision. The comparison of the one in front and behind. Oh, that's not a bad picture. Those are good pictures because the one from behind you can see. The concerns that we heard from the neighborhood was about height, mainly, is from what I could tell, and I do know that they were suggesting that 3 to 4 stories would be much more acceptable in this area. So I'm thankful that staff was able to meet with the proponents to make those changes, because the other one, as is demonstrated here and as we were hearing, is quite a bit higher. I hope that if in fact this receives approval, that the proponents identify the proper trees that are next to them, and which was a concern voiced by some, that we retain as many trees we can around the development. And if in fact this is an indication of the trees that will be retained in this drawing, because they've done such a good job of it, that's helpful to me in my decision making, is to keep a buffer to the neighborhood, Trident Avenue and behind, and to retain the large trees, mature trees that are there, because from what I know of the lots themselves, there's mostly buildings and hedging, not necessarily the large trees that I would hope that they would retain. Once it's built, then to replant trees to then wait for their maturity is a little bit counterproductive. So I hope they retain those. Those are just my initial comments to say that that's what we were hearing from the neighborhood, to make it smaller. They have, although I will say that I do like the look of the of the original building a little more, and I don't know what that exactly changes, cladding or things like that, or railings and the way they're windowing versus, I don't know what the white thing is, but I do like the look of the original building, but I'm not a design architect. I just in terms of curb appeal and what it looks like from the street is helpful to me. And I was wondering, the lane, the yield lane into East Porpoise Bay Road was mentioned by the planner, and I'm wondering, because that was identified as an issue, could an island help with that? Would that help with that issue, a small island in terms of the crosswalk? And just to suggest. Thank you.
And Councillor Mueller?
Yeah, I wanted to bring up the landscape plan and the associated parking. I believe it's page 89 and 88. In the agenda, yeah. That'll do. And the one before in particular shows a gray area along the, I guess that would be the south side. Is it still the parking, the only ingress and egress onto East Porpoise Bay? Or is there now an entrance to that parking lot off Wharf?
Through the chair, it's not showing any additional accesses at this time. We haven't had a lot of detail of how the circulation actually works for that building. These are the only drawings that we have received. So I'm not sure how it basically works. I believe it, the only one they are showing right now is off East Porpoise Bay.
But it looks like the only way to park in those stalls along the back of the building would be to come off Wharf, turn right along that light gray area. They're not going to be coming from downstairs from the underground parking. They'll be turning right. That's what the proponent is thinking too. That's what I thought when I first went through it.
It was just challenging to figure it out from the proposal.
Yeah, but that's the
how it's
intent.
coming in. I would assume they would have to.
So that'll be, in a sense, an additional buffer.
Yeah, I just wanted to be clear on the parking and the way that that works because it's not absolutely clear here. And maybe we can shed some more light on that in the future. Is this is complete then?
That's underground. That's the underground parking.
Okay, so maybe that's something that we need to clarify a little bit better with the applicant. That may have further ramifications on the traffic impacts of this, which are, as we've noted, are important. So important to the community.
Because if they turned right off Wharf to go into those parking stalls and then came out the same direction, they'd be crossing 4 lanes of traffic if they wanted to turn left. And otherwise, everyone has to go down to the lighthouse before they can leave. Councillor Wright.
Thank you, Your Worship. My question's around the affordable housing units. If my memory serves me correctly, we've had difficulty when we've accepted affordable housing units and how we are able to dispose of those. Is there still an opportunity to get cash in lieu rather than the units?
Through the chair, that can be the decision of council. The challenge has been the financial aspect of it is only, I believe, $210,000 per unit, which doesn't cover very much. But yes, it has been a challenge in previous ones, mainly because the condo fees and additional charges have been problematic.
I guess what I'm thinking is maybe we should be looking at that cash in lieu rather, and I understand that it's not that much, but when you have difficulty moving the units because the strata fees and things like that are so high that people can't afford it, they become problematic and you just can't get rid of them in terms of affordable unless you just put the price back up to what the market will bear. something we should be thinking about. Thank you.
Following up on Councillor Wright, does the district have the option of accepting 4 units as affordable housing and then remarketing them at market price and using those gross funds for our affordable? If we take the cash from the realtor or from the developer, it'll be $210 per unit. If we take the units, it might be $350,000 a unit in today's market. Or do we have that option, or is it, you don't know it? Okay. I would like to at least explore the ways to maximize the affordable housing. If it's good affordable housing that people can get into and it works well, but we have had problems with the Watermark, for example, where people who qualified for the affordable side of it didn't want to live there and couldn't afford the monthly maintenance. To go back to the per unit amenities allocation that we had at the very beginning on Stratus. So that's something I'd like us to at least, I don't want to see us get into real estate plays, but we are trying to solve some problems. Councillor Lutz.
Could we go back to page 88? I'm seeing on that drawing the circle that was originally a commercial space. Will that be remaining? It doesn't show in the other pictures.
Yes,
Sorry, through the chair, from what I understand, it does. We received the drawings. We haven't had a lot of discussion at this stage, but my understanding is those values haven't changed. It would still include the commercial.
Any further discussion? I have 2 concerns. I don't think the 4 stories and the density will actually alleviate the concerns of the immediate neighborhood, but I think we do need density, and 4 stories seems to be the direction we're going. I'm really perturbed about the traffic and the roadway inconsistency. Turning that into an even larger industrial road to take trucks going into East Porpoise Bay defeats the entire purpose of turning it into a pedestrian area where people can access the marsh, access the waterfront, access the wharf in Porpoise Bay, which is all of this is only 2 blocks away. So the idea of trying to create a wonderful walking place with a higher density, with more people living down there, more people in the Ebb Tide Village, more people close to the marsh on Ebb Tide, and then creating a 4-lane, 3.5 lane now, and you've got another lane, you're waiting for the next one. It just doesn't make sense. So the sooner we can deal with the sea shelf and get Tika Way as an actual route from Highway 101, past the hospital, past the gravel operations, to East Porpoise Bay Road, the sooner. And then everything in that entire corner from the Bandlands, including the Bandlands, over to East Porpoise Bay, could become a neighborhood that people would like to live and walk in. And if you step out of your front door and the first thing you hit is a semi-trailer going and putting an island there so they can cross halfway and then wait again is a little bit of a safety solution. You know, they can get 4 yards and then they can get another 10 yards. But I just find that, I understand why engineering is asking for it. I just think we should refuse engineering. We should tell the traffic to continue to be slow and difficult, keep the roadway small, and push to actually get a decent roadway where it should be, and rather than make this an interim, because we'll never get it back. Can't imagine planting it with grass in 15 years. If it's there, I'd actually rather turn that entire roadway to pedestrian-friendly walking with wharf and fixing that up, and tell the everyone who needs that for deliveries to pressure us and the SCRD and the First Nation to do some decent work on Tika Way. Just my thoughts. As you've seen earlier, I have no influence on council. So, Councillor Inkster.
Yeah, we all know what problems we're facing with congestion on Wharf Road with some recent events. So we know maybe with redirection, we should be encouraging that. But if we want in terms of that particular intersection and some others, and even the highway that goes through town, which kind of extends this discussion, we should be looking at center meridians with perhaps gardens or smaller, something smaller than that even to control traffic a little better and pedestrianize our town. It's something that I've seen elsewhere, and if that's what we're talking about, and there is some encouragement and support from you for that. I'm not saying we should necessarily will do it tomorrow, but it's something we should be talking about because that's the way we start to calm traffic and make pedestrianize more, is narrow it and put more of those meridians in with some gardens and such. And we've seen them elsewhere, and it makes those towns and those roads look quite a bit more beautiful than the utilitarian roads that sometimes just move traffic. So that's something we could consider with this, with the fact that we have some good cooperation from the developer with some of the work that they want to do there. So something we should be talking about.
Thank you for that, and I'll look to Councillor Lutz, and then I'll look for the second recommendation that directs staff to either prepare a revised zoning bylaw or not.
I agree with the walkability of this part of the community. It's one of the reasons I think we need the density there. And we've talked today at our committee of the whole about connecting trails, walkways, a boardwalk around the bay, all those things aimed at pedestrian friendly. So I too think we need something other than multiple lanes of traffic through what is a perfectly walkable neighborhood.
We have a recommendation that council directs staff to prepare a revised zoning bylaw number 25 to give effect to this design proposal and bring that bylaw back for consideration of second and third readings. And I think at that time we'd like some clarity on some of the questions that were raised today in terms of parking and access from wharf and those issues as well. Councillor Wright, moved. Thank you. Seconded. Any further discussion? If we're okay, all those in favor? Any opposed? That went through. Yes, I don't know if it will meet the concerns of the neighborhood, but we'll see as it comes back for second reading. Council supports it. And we'll ask Councillor Lutz to recuse herself as we're moving again back into the West Porpoise Bay Estates. And I want to thank everyone for their patience. I know that from the fact that nobody's left yet, that a great number of you came just for this. So, and unfortunately, we may not conclude it this evening, but let's start with the item 10.2 and the report from the Director of Planning regarding the West Porpoise Bay Estates be received. Thank you, and seconded. All those in favor? That's carried, and I'll turn it back to the Director. You've had a very busy night. Your voice is standing up better than the Committee of the Whole delegation this morning, so we won't advise you on how to do that.
Thank you, Your Worship, members of Council. This is a application seeking reconsideration of the variance permit for height and seeking clarification on the preferred direction here. So the applicant is, as you heard, RTC Properties Limited. It is an R4 zoning, looking for permission for an 80-unit, 6-building strata development located off Marine Way. That is the location. In terms of what they are proposing, there are 2 buildings that are 4 stories. That's building 5 and 6. And 4 3-story buildings of 12 units each, and those are the ones that essentially run along the Strata Road. In terms of the chronology, we did, the application came in kind of summer of 2017. Post-referral went out that noted the height issues and the DPAs in October of 2017. It went to APC in December. They recommended approval as presented. In February, the Planning Committee recommended the variance for buildings 5 and 6 only, as they weren't really visually impacting the surrounding strata. The council endorsed the minutes, subject to the notification to the strata regarding the variance. Following the notification of that, it came back to council. There were a number of concerns raised by the people living adjacent to it. I believe we sent it out to approximately 130 people, and I think in terms of the concerns related was significantly lower than that. So in terms of the height and what is driving a lot of the need for a height variance is the fact of how we actually define height and measure it, of taking the average natural grade, which works fine on most areas, and then in a very steep slope, it certainly affects what your minimum, maximum heights can be. So when it's adjacent to a very steep slope, it affects the ability of what that 10.5 looks like. For the majority of the buildings, as noted in the report, if they were actually doing this on a level site, you'd probably see a 3-story building with underground parking. Very similar to what shows up in a lot of our R4 sites, and that's what's intended to do. On those buildings, they're against a slope and it kicks into height variance, but those particular buildings are very in keeping with the kind of structure that would show up in an R4. As mentioned in our meeting earlier today, they had looked at a revised site plan with no variance. This is kind of a variation on the original Form P that was presented today. It does keep it off the 15-meter setback. It would involve, I believe, 24 buildings, if I got the count right. So the issue that staff had and why this was coming back for reconsideration is if you looked at the buildings from that strata road and what is adjacent to the existing strata, it doesn't really impact at all or improve, shall I say, the viewscapes from that. It's still a 2-story from the strata road. In order to make that work. So it wasn't improving that. In fact, the buildings are a little bit tighter, so the view corridors are reduced on that. The other concern that we had was showing up here in the green, that's new road that needs to go in to access the additional buildings. So concern there was that's a lot more infrastructure, it's a lot more cut and fill. While it would negate the need for a height variance, it's certainly a more impactful development on that site. It's more building, it's more blasting, particularly in that area below the other buildings 5 and 6. It's putting a whole row of development there that didn't exist before. So that was the concern, is that it met technically, it didn't need a height variance, but I'm not sure in terms of the concerns that the public had with this development and the concerns that we have in terms of alignment with the steep slope development guidelines, that this really got us where we needed to go, hence why it was coming back for consideration. This shows the alternative on that and how much site alteration is required. This is, if I've got this right, and please correct me, this is off the existing building in phase 3, right? I think it's a rounded one. So buildings 5 and 6 are sunk down there with 2 roadways. I didn't have, or at least I couldn't access the ones that actually show along the strata, but those are up higher along the existing strata road. I'll skip through this because you presented that. But it showed that the change from that existing Form P and the original development that put quite a bit of units down toward the waterfront there. The proposal now was to do slightly larger buildings. It still kept the unit count, but it was in a different configuration that left a little more open space at the inlet side of this development. So in terms of the variance request in the revision, what we found in looking at it in terms of the actual numerics is that some buildings actually increased and some decreased. There was a building in particular, building number 5, that increased. I believe it was because the previous measurement may not have been accurate, but also the architect shifted the building slightly to reduce impact. That meant it's on more of a slope on one side of that building, and so in doing the average grade, it pushed it up, which seems counterintuitive because there was some work done of changing out the type of elevator, so the elevator shaft wasn't as high against that strata road, and changing the ceiling heights on some of the buildings so the whole thing could come down. So on those first ones in building 5 and 6, a lot of that is just really because of the way the slope drops off at that point. Those two buildings are on quite high stilts on the one side of them. In buildings 7, 8, 9, and 10, those are it's reductions on decreasing on 8, 9, and 10, slight increase on 5 and 7. In terms of the form of the buildings and the access to them, that hasn't been altered. It is largely the same type of development. This shows in building number 5 this is quite a bit lower than what you can see on that existing strata road. It's not blocking the visuals on this particular side. And then the parking coming in at that grade level. On the other buildings, so you can see on these ones, these are buildings 7 and 8. The two-story is against the strata road. Most of the height is actually down slope, and the access to those buildings and the parking is actually interior to the building itself. That's what helped reduce the impact of the road, the infrastructure on that particular site area. Those are very similar. Those are just in 9 and 10. You can see how in 9 and 10 they're just a little bit lower into the ground, so the height difference was a little bit different in terms of the variance. This did not come out well on the PowerPoint. It is in your package, I believe, and it shows more of the area around the inlet. The applicants were proposing to provide additional park area that is adjacent to the inlet, essentially across from building 8. The renderings haven't altered too much. This was shown previously in both committee and in council meetings. So just to go back, this is what you would see from the inlet side. Most of the balconies, the height is mainly on that particular side. When you get to the strata road, they were very deliberate in terms of not having a lot of oversight onto that road for privacy purposes. In terms of the scale, it's remaining at 2-story. These are from the previous one, so they have lowered some of the mechanical on the roof related to the elevator. Again, from the strata road. We use the same pictures.
That's the actual road.
And so the recommendation to be considered, and the reason that at the end in your report it has an "and" that just sits there that should have come out, it's because we didn't put the other recommendations for the development permit in at this time, because they're really predicated on bringing this variance back. So if that is supported, when we, and we bring it back to council, we'll have the full development permit in there. But you do have the guidelines, you do have the detail in the report of the development permit application and the evaluation that goes with that. And that concludes my presentation.
Thank you for that report. And we'll have some discussion, and then we'll try and determine how we proceed. We spent a good deal of an in-camera meeting this afternoon with our own legal counsel to determine what the District of Sechelt's interpretation of much of this is. I can say that it's turned into a very complex, messy, I'll call it a messy file. That's really what it is. And the District of Sechelt and Council can only consider planning issues and zoning issues. There's been a lot of misguided talk about what a Form P is and what it isn't, what an approving officer does and what an approving officer doesn't. There's been a lot of misguided talk about OCP guidelines. And we can't, for the developer, change the fact that this is the land they bought and it's got R4 zoning on it. And for the residents who purchased into earlier phases, we can't change your purchase decisions. You made those and we don't know what they were, and we don't know what your reasoning was when you signed various forms releasing for the next stage of development. From our perspective, a Form P and the approving officer's authorization of that is simply a stratification document. It's not a development document, and that's why it's in front of us, because we still need to do the planning and the development permits and development variances. So the what is or is not in a Plan P or how it operates is about stratification, and as was pointed out, the unit contributions and the sizing. So that's really important, but that's all it is. Important for us tonight is the development permit guidelines, pages 116 through, where the director has done a very careful job of taking through every single development permit area and whether the guidelines were met, partially met or not met. And with that, I'll ask the councillors to consider it. I have to say I am concerned, and we may come to this before the evening's over. There's only 4 councillors with us tonight. And on difficult decisions, we've usually made sure we have a full council. Now, in this case, Councillor Lutz won't be with us, but Councillor Seegers, who has a particular and important point of view on development issues, and Councillor Shanks, who has a longer history. He might have even been around when they first zoned this R4. Not in 1991, but no, not in 81, but in the 93 ones, I think they were. So that, and those viewpoints are important to us, and we're not sure what they would be. But I'll throw this open to council discussion at the moment to see how we should proceed. And thank you, staff, for the detail in this report and the attempts to keep it to what council can and can't do. We can't solve problems that other people entered into. And Councillor Mueller?
I'm happy to jump in here. This council, of course, is under tremendous pressure from the development community on many fronts. And this one, no different. As well, we're under pressure from the community to deal with this stuff fairly and to preserve neighborhood character and the like. Whatever decision gets made by council is bound to be incredibly contentious. There's a lot of units here, and I would be in favor of deferring this to a night when we have more of a full council, so that the vote that gets made is something that the community and the developer can live with.
Is there a second? Motion to defer, seconded. No discussion on a motion to defer, so I'll just ask how people stand on that. All those in favor? Any opposed? Then it will be deferred until we have a full council. Before we do that, is there anything that councillors need in a final report based on our discussions or what you've seen today or not seen today? Because we don't want this to take any more rambling routes. I think we have, the reason I wanted to present it tonight is to see exactly what was in front of the public and to have the RTC delegation, to have the technical report from our director, and to consider that in terms of our legal discussions this afternoon. And I think it's probably wise to allow us to meditate on that for some time. It was a very interesting discussion. Anything that we can direct for planning to make sure when it comes back, we've got everything we need. Director Inkster.
Yeah, I guess I didn't expect the motion to defer so quickly, which there's no discussion, so can't really talk much about it. And
you can now.
We can now.
Not about the motion to defer.
Not about the motion to defer. That's very specific and triangulated, sort of what we can't talk about, so I won't talk about that anymore. But in terms of the proposal in front of us that was presented, you know, going forward, the thoughts that I have is that yeah, the work that's been done, the look of the building, I like the look of the building, and it will be interesting, the look of the buildings from the water. That's a nice look in terms of the buildings, and the developer has put a fair amount of good work into that, and also the rehabilitation of the site from what had been presented and what we've been hearing from some members of the community, that it will be a better site. But going forward, and as I consider my decision going forward to that decision in September, I'll be listening very intently and remembering very intently what a number of the residents spoke of in the area, and then comparing it to my thoughts about height and how our OCP is reflected within the presentation of the proposal and the buildings presented. So as I tend to and a lot of times do, I listen very closely to what those directly affected and a lot of members of the community that are affected by the development have to say about how it will change their neighborhood and their lifestyle. Thank you.
Any other comments before we move on? And I'll have some wrap-up comments. Councillor Mueller.
Yes, thank you. And seeing this new, the original different proposal, there becomes a real focus on the blasting and the change of grade that will happen if we accept a second iteration or not. And I know that there was a geotechnical study done, but I believe staff should perhaps follow up and deal with some of those issues and come back with us with more of a complete analysis of that, because we are dealing with multiple story buildings and we're dealing with potential fill and blasting on a steep slope. I think that needs to be dealt with when it comes back in a more definitive way.
Okay, a bit more information. Anything from Councillor Wright? No, we're fine. I would say two things to the developer. This will be, if we decide not to have a height variance, you'll have a decision to make about the amount of infrastructure that's involved to get the units and the density you want, and that will be a decision that you make. We have an R4 zoning which gives a maximum density, not a minimum. To the residents, if there's no height variance, that doesn't mean the height of the buildings in front of you will change. As we look at these proposals, the height will come off the bottom of the buildings, not off the top. So if it becomes 10.5 meters, it might still start visual from where you are. So don't assume that the height means everything slides down the slope. The pictures that we've seen indicate that height will probably come off the bottom of the building, not off the top. So just keep that in mind as well. Council really does want to do what's right for the community, and we want to make sure that all of councillors can weigh in on this. And we had a fairly lengthy discussion today about focusing with our legal counsel on just what the planning issues are, and we're not going to try and solve problems that are extraneous to that. We can't do that, and it's not our right to do that, or not our, that's not our burden. Let's put it that way. There's enough of a burden on this decision. Thank you, and we'll address it after the meeting if people want to. Council 10.3 is council policies, report from the Chief Administrative Officer. On first, a motion that we receive the report from the CAO. Sorry. Oh, yes, Councillor Lutz. I'll give people a few minutes if they want to leave while Councillor Lutz is coming in. Baby's sleeping. Good. Cold outside? Oh. Okay, moving along, we're at item 10.3, and I need a motion to receive the report from the CAO. Thank you, seconded by somebody, thank you. All those in favor? Mr. Yates.
Thank you, Your Worship. Not much to say on this. This is the final work from our consultants, Perryville and Taylor, from their organizational review from 2015. Our HR advisor and other members of staff have worked very hard with Mr. Taylor to get these final policies done. So we have a conflict of interest policy both for council and another one for employees. We have a code of conduct now before you for both council and for employees, and we have solidified our respectful workplace bullying, harassment, and discrimination policy. And that was finally tidied up after we did our first round of training for staff and council on those issues. Thank you.
Thank you very much. And we have 2, 3, 4, 5, and 6, which is 5 recommendations. Do we want to do them individually or all at once? Let's get a motion to adopt recommendations 2 through 6. Councillor Mueller, Councillor Lutz. Now, discussion of any of those or any particular parts of the policies that people would like to draw to their own attention or to the public's? Director Mueller, Councillor Mueller.
So just to be clear, there have been no changes in these policies? These are just for our receipt and reminder?
They're new policies. We don't have them.
Yeah, these have been written. These aren't old policies. The only one that did exist in a better form of one kind was the respectful workplace. That's been updated to reflect the latest in WCB requirements and also from our safety consultants.
Okay. And the reason why I asked that is just because to me this is non-typical in terms of how we do policy. So I have some concerns about that they're all coming in a package. Council basically is the first time we're seeing them. And so I understand how they came about, but to me it's non-typical.
Yeah, I think, and I agree with that. We had workshops on the conflict of interest and the code of conduct back in 2015, and then nothing. So in terms of taking them apart and actually discussing them and going through them, again, if this is an item that we'd prefer to defer to a workshop, I would understand that quite in keeping. It is 3 months to the end of the term. They should be in place, we hope, as the term ends, but I could certainly understand referring this to a workshop for council and senior staff. If others, and that would meet your needs, right? Councillor Lutz?
I would be more in favor of letting them stand and amending as necessary if there are things of particular interest to a councillor that they feel it needs a change. But having read through them, most of them make sense. Most of them are things we've talked about in the past. I just don't want to see it set aside and not dealt with.
Yeah. And they do follow the community charter and things of this nature. Councillor Inkster?
Yeah, we've as has been indicated, this has been something that's been on the table for a number of years to be dealt with, the information and some decisions, and the policies are in front of us. I would certainly support moving them forward, as Councillor Lutz has indicated. If in fact there's particular issues presented herein or some policy pieces that Councillor Mueller would like us to talk about, I see no reason why once it's passed he can't present those to the mayor to be brought to a committee of the whole meeting as soon as possible, or maybe in the next few months based on some of our other things that are going on, in order to make changes to those particular policies that he has issues with for a full discussion.
Okay, any other thoughts on this? Then we do have the motions in front of us to endorse policy on conflict of interest, on council conflict of interest, on employee conflict of interest. They're different. Council code of conduct, employee code of conduct, and the respectful workplace bullying, harassment, and discrimination. If there's no further discussion, all those in favor? And any opposed? One opposed, that's carried. And I do think it's appropriate that we read them carefully, and it might be appropriate, even if it's not a workshop to develop and think through the policy, a workshop to make sure that every council member and senior staff understand the policy now that it's in place, would still be appropriate, even though there's only 3 months left in the term. I think that would be useful. And that would be a point for discussion, because no sense having words on paper that are put off to the side and people don't follow. That takes us to item 11, reports from councillors. One advantage of having only 5 here tonight is the councillor reports might proceed more quickly. I'll start with Councillor Wright on my left.
Thank you, Your Worship. I'll try and keep it brief. Spent some time with the community engagement at the farmers market regarding community forest. Also attended the community forest annual general meeting and Public Works Planning Committee and Finance Committee, and then a closed council meeting. Had a number of meetings with individuals living within Sechelt, asking me all kinds of various questions about water, water meters, and miscellaneous other things that will happen in October. And that concludes my report on behalf of the District of Sechelt. Thank you.
Yeah, and I'll let me mix this up tonight and start now on my right. One's to the left, one to the right. Councillor Inkster. I'll move back across here.
Okay. So just a couple of quick things to mention. The mainly community forest related, the World Cafes that I didn't speak to last council meeting because I had to be away, but it was good to see the attendance, although I didn't see the daytime one. I'm wondering if other council members did. It's good to see the attendance at the nighttime one, to see the good large turnout, the good cross-section of our community, although as I've said, I want to see, it would be good to see a lot of Sechelt people at those events to talk about their community forest, because it is theirs. But it was generally good to see the dialogue, and that continues at the farmers market where we have been, and I want to thank staff for providing a fair amount of materials and mapping and such, because I think it needs to be clear to people where the community forest is harvesting and some of the work they're doing in the local forest. So those have been interesting opportunities, and just to let the public know, I think we'll have 2 more of those opportunities. One in Roberts Creek, I think, is in development, and one more at the farmers market, although I'm not sure how many of us will be around that weekend, to hear from the public on the community forest. And I am bothering staff about more documents that I'd like to see on the community forest that will probably most likely be available to council once we determine what it is helpful. Just wanted to mention in closing that I was in the Sea Cavalcade Parade, doing what I do in the Sechelt Parade, but obviously in a different role. And it's always good to be in those parades, and that was another good event, much like our Canada Day, and once again well attended. And it's always good to see thousands of people come out to many of our events on the Sunshine Coast, and we have a few more of them before the summer sets. Thank you.
Thank you for that report. And Councillor Lutz.
Thank you. Attended a lot of the meetings and connections with the community around Community Forest and their annual general meeting. Also, on behalf of the mayor, I attended policing and transportation at the regional district, those committees, and a board meeting and a hospital board meeting. But I hope I'm not stealing anybody's thunder. I had planned tonight to announce that, yes, I will be putting my name forward to stand for a councillor's position on the District of Sechelt Council in the upcoming election. That's my report.
Thank you for that report, and thank you for standing for public service again. Councillor Mueller.
Thank you, Your Worship. For my report, I was on vacation last week. I went to the Kootenays. I had a chance to see the way they do community forestry there. And if you're ever in the area, I really recommend that you go and check out the tenure of the Harrop Proctor Forest. When you're standing in front of the mountain upon which they do all their logging, you can't even tell that it's there. And it's quite impressive. Right at the bottom of that mountain is a mill where they take all of the wood and employ about 35 people at that mill producing finished products in a town with almost no employment. So that was really great to see firsthand. I hadn't been there for a while to check out the cut blocks, but you saw the mayor allow me to go last because I have a bit of a statement here to make. And that is that for my friends, supporters, and colleagues, today I'm announcing that I will not be seeking a second term on Sechelt Council. And this was a very difficult decision that took many months to make, and I did not make it lightly or in passing. I sought feedback from community and consulted with my family, friends, and trusted advisors. In the end, it was my choice alone to make, and I have now made it. I want to thank my supporters, first of which was my partner, Georgia, who provided the vessel with which I could do this work. Also, to staff, community, for making this such a success. I have immense gratitude for the collective experience over this past 4 years. I love my community, and that's what made this decision so difficult. I know that in the view of many in this community, I'm needed on this council. And I've seen it many times, and I do not dispute the impact I personally had by holding public office in Sechelt. But in order to better explain my decision, we will need to go back to the beginning of how I got started in my run for public office. Just take a minute. In order to better explain my decision, I need to let you know I started politically engaging in 2013 as part of the U-Turn generation movement of leaders in my generation that are seeking to address the foundational issues in our society that are eroding the very basis of sustainability for future generations. The very lives of our children and your grandchildren are at stake unless we get to the root of our collective dysfunctions and address them. This isn't a game, and there are no reruns. I began as an activist and quickly moved towards organized politics and then to government. And along the way, many have tried to leverage my energy to their own ends, and I have refused to become someone else's adjunct. I came of my own volition and have always spoke for my understanding of what is right and wrong. I'm now 5 years down this path, and I'm still moving rapidly with clear intentions. That much will not change, although the venue may. All the time, I've been seeking to learn what the issues are and how in the future my generation will be addressing them. Never at any time have I been swayed from my path by trinkets, accolades, or offers of influence. I wanted to see these issues from inside government and understand what is going on. One thing has always remained clear: it will be left to my generation to undo years of careless neglect of our environment, public institutions, and society at large. It's our world to create, and create we must. This will require both creation and destruction to achieve. The truth is that the next words in this poem cannot be spoken by the voice of government. The changes that are now required of us are so fundamental that government will never be the originator. This needs to come from the grassroots through groundbreaking societal change. In today's world currently, we're divided by politics. That much is abundantly clear, and that's at the heart of what's wrong. It's been more than a generation since we've been united in any common cause on anything, and that needs to change with politics along with it. More than anything else now, we need to move towards unity because there's a storm coming and we're going to need all the help we can get. In the coming months and years, you are still going to see me doing important political work in this community. My intention now is to focus on things that are less political and more foundational, and I hope you will join me in that work. Along with that, I will be focusing on synthesizing what I have learned towards producing lasting solutions that are both national and international in scale. You will get another chance to vote for me in the future. And in closing, I would like to offer these thoughts. The political spirit of my generation has so far neither been explained nor understood, and the time has come for us to renew our commitment to a better future and join in creating it. We are not destined to some depleted future unless we choose to accept that. We've faced worse and come out on top as a society time and time again. We have all the tools we need to produce the world we want to leave our children. We just need to use them. I will continue this path with the utmost dedication and commitment and all of my energy until I perish in the pursuit of a better future. Thank you.
We're going to miss you. Around this table, but not in the community. So, SCRD Board, Council Representative Report. We had one meeting that I missed on Thursday. Anything to report from that?
Oh, thank you, Your Worship. I'm truly sorry to hear your decision. However, at the SCRD, had an infrastructure agenda planning meeting. Then we had the infrastructure committee meeting. There was a number of reports. One of the most interesting reports was the emergency services agreement. The SCRD for a number of years has been operating with the emergency services, which is your 911 and all those various things, without an agreement in place. We're not the only people that miss something, okay? And it's been going on for years. After that, there was Transportation Committee. That was an interesting committee meeting. There wasn't much, but we had also a meeting with the CAO of BC Ferries. And he went on to explain to us some of the difficulties that he's having hiring people. He said, I got a ferry sitting down in Langdale. He said, I couldn't operate it tomorrow because I have no staff and I can't get them. I have a human resources person who is searching the world for qualified people. And when I get them, they find out the price of housing or how far they have to commute, they're not interested in coming. So he's got a real problem, and they're actually thinking about their new ferries are going to have living accommodations on them so they can attract people to come and work for them. So that was an interesting meeting. Also, the police commission was quite interesting. During the months of January, February, and March, there were 40 thefts from unlocked cars on the Sunshine Coast. Just a heads up for the people. There was also a CAS meeting, Corporate and Admin Services, and there was a number of reports. Basically, the reports were second quarter reports. That's where they tell you where the position of the finances and all of those various things, similar to what we have. And then there was a board meeting. The most significant thing at the board meeting was a motion to abandon the water meters, okay, because the alternate approval process failed. And there will be a subsequent report of where we go and what we do next with that coming in September. And lastly, there was the Regional Hospital Board meeting. And I would be remiss if I didn't say something to you about the Sunshine Coast Healthcare Auxiliary. 80,000 hours of volunteers, 500 members, 6 branches, just under $1 million going to the hospital in 2018. $15,000 in bursaries, grants of $80,000 in 2018, with it going to $90,000 in 2019. They are partnering with emergency services and the homeless shelter. They make up to $48,000 per month, and $3,300 was their best day. They have the highest satisfaction rating for service on the Sunshine Coast. Just a few tidbits for you. That concludes my report.
Thank you, and it's a good way to end the report. Do you have anything to add on the RD? And then, yeah. Well, it was either at the very end or at the end of that. I was actually thinking, Councillor Mueller, if what you were reading was in a, or some of what you're reading, or some of your comments are in a text, if you could forward that to council. And we might see if it's important to understand it. Moving on to item 12.1, council correspondence for receipt. Motion to receive. We've got 4 items. Thank you. Seconded. All those in favor? Any of those, that's carried. Any of those 4 that people would like to speak to? In that case, I'll look for a motion to adjourn. Thank you. All in favor? And we are adjourned. Ms. Jackson.